We have considered the rival submissions of the Learned Council for the Uplands and Learned AJ as the punishment under section 3 within bracket 3 of the quota extends to life imprisonment and fine merely because the accused had undergone 7 years in jail cannot give rise to an ipso facto entitlement for bail to the appellant on this ground. It is noteworthy that the review committee headed by Justice Naseemuddin had observed in the order dated 22/9/2004 that it could not be said that no prima facie case was disclosed against the accused so that a recommendation could be made for withdrawal of the case under section 60 within bracket 7 of the quota. Yet as the committee had stated that there was no public witness of recovery and the papers appeared to be weak, it was open for the state to consider whether it would like to withdraw the prosecution of the appellant under section 321 CRPC, but merely from this opinion, which was of a neutral, non-binding character on the state government, it cannot be urged that a case for bail was automatically made out para. Here it may be noted that in the earlier order dismissing the appeal passed by this court on 13/12/2006, which was filed against the rejection of the second bail application, this court had specifically observed that the recoveries from the accused appellant Javed Elias Guddu and his accomplice suggested that they were involved in anti-national activities with intent to threaten the unity, integrity, security or sovereignty of India and spying from Pakistan. In this context, it was pointed out that on 3/8/2012, the STF had apprehended the appellant and co-accused near Raja Degree College, Rampur, and from their possession inter alia visa of Pakistan passport dated 11/4/2001, a letter dated 31/12/2001, over which A and J were written, and letter M was coded out, addressed to Sri Amir Bhai of Pakistan. Marriage invitation card on the back of which 1820 code numbers were written. One line paper over which details of the movement of the army from Dehradun, Bareilly and Meerut were inscribed, and a small pocket diary containing telephone numbers, addresses and details about the army code words, etc. were recovered. On overall view of the circumstances brought on the record of the case, this court is of the firm opinion that the deceased did not die of suicidal death. The next question which calls for consideration of the court is whether the deceased died an accidental death as observed in the earlier part of this judgment. The case of the appellant is that while boiling milk for the infant, the clothes of the deceased caught fire accidentally because of the flames emanating from the stove, as a result of which she died. The Panchnama of the place of incident establishes that the place suggested by the defense where the deceased was found engulfed in fire is a narrow passage where several articles were lying. If the deceased had died because of the flames emanating from the stove, the other articles lying nearby would have been found to be burned. However, admittedly, the Panchnama of place of incident does not indicate that any article was burned except a towel which was found partially burned. Further, the story put forth by the appellant that at midnight, the deceased had got up for boiling milk for the infant itself does not inspire confidence of the court. The deceased, who was a teacher by profession and well educated, must be breastfeeding her 3 months old infant, and it would not be reasonable to infer that the infant was being fed buffalo or any other milk. It may also be mentioned that the deceased, in the company of the appellant, had left her parental home between 11 p.m. to 11:15 p.m. on April 5, 1983, and must not have gone to sleep before 11:30 p.m. From this fact, it would be reasonable to hold that before going to the sleep, the young infant child must have been fed, and the child would not have required another feed within 2 hours. Thus, the story that deceased got up at 2 a.m. in the night to boil the milk for the infant does not inspire confidence of the court. These are some of the material and vital aspects which clearly demonstrate that the trial court has carefully analyzed the entire evidence on record, and the view taken by the trial court is certainly a possible or plausible one. In our considered opinion, the approach of the High Court in the impugned judgment is not in consonance with the settled principles of criminal jurisprudence. The High Court, while reversing the judgment of the trial court, observed that in all probabilities I am inclined to hold that there was demand of dowry, and the deceased was harassed by the first accused, and therefore she committed suicide. In criminal cases, the conviction can be sustained only when there is clear evidence beyond reasonable doubt. The accused cannot be convicted on the ground that in all probabilities the accused may have committed the crime. The approach of the High Court is wholly fallacious and unsustainable in law. The real question which falls for our consideration is whether the view which has been taken by the trial court was a possible or a plausible view. We have carefully perused the judgment of the trial court and the impugned judgment of the High Court. The trial court very minutely examined the entire evidence and all documents and exhibits on record. The trial court's analysis of evidence also seems to be correct. The trial court has not deviated from the normal norms or methods of evaluation of the evidence. By no stretch of imagination, we can hold that the judgment of the trial court is based on no evidence or evidence which is thoroughly unreliable, and no reasonable person would act upon it, and consequently the judgment of the trial court is perverse. We also fail to arrive at the conclusion that the discussion and appreciation of the evidence of the trial court is so outrageously defies logic as to suffer from the vice of irrationality, incurring the blame of being perverse, and the findings rendered by the trial court are against the weight of evidence. The law is well settled that in an appeal against acquittal, unless the judgment of the trial court is perverse, the appellate court would not be justified in substituting its own view and reverse the judgment of acquittal. Heard the submissions advanced by learned counsel for the parties, this court found that the adjudication proceedings are still pending before the appropriate forum, and the said dispute can very well be adjudicated upon by determining the liability for payment of excise duty. This court abstains from recording any finding on the issue of payment of excise duty levied upon the applicant and others, which is sub judice before the appropriate forum. This court is proceeding to record its finding only to the extent of bail matter, since the arrest of the applicant was made for the offence under Section 9 of the Central Excise Act, and the arrest was effected under Section 13 of the Central Excise Act. This court cannot delve into the issue of fixing the liability of excise duty, as the adjudication proceedings are still going on before the appropriate forum, which will determine the liability of excise duty taking into account the evidence led by the parties. Section 9 within bracket A of the Central Excise Act contemplates that the offences under Section 9 of the Act shall be deemed to be non-cognizable. The matter is also compoundable as per Section 9 within bracket A of the Act as amended by Finance Act 23 of 2004, making the offences of the Act compoundable either before or after the institution of prosecution. The provision of inquiry by summoning the person is also engrafted under Section 14 of the Act in spite of existence of such provision. Without ascertaining the facts, the respondent resorted to Section 13 of the Act and arrested the applicant and exceeded by taking steps to remand. Thus, in my opinion, it will not be justifiable to keep the applicant behind the bars, ignoring that the adjudication proceedings are pending. So far as the liability of tax is concerned, whatsoever liability is determined by the appropriate forum, the applicant cannot escape from it. Since the offence is non-cognizable, there is no chance of misuse of bail, tampering with the witnesses or absconding. The offence is also compoundable, therefore the applicant is entitled to be enlarged on bail. The Honorable Apex Court has held that if a single judge of the High Court does not agree with the earlier view expressed by the learned single judge of the same High Court on an identical point, then the matter should be referred to division bench instead of deciding the same. It is also argued that the judgment referred by the learned counsel for the applicant that in the matter of Vasudeva versus Ram Singh and another Supra is a judgment inasmuch as in the case of Bharat Petroleum Limited versus Mumbai Shramik Sangh, the Constitution Bench considered the rule of judicial discipline and propriety as also the theory of precedence and held that a bench of the same quorum cannot question the correctness of the decision by another bench of coordinate strength, in which case the matter may be placed for consideration before a bench of larger quorum. It was further held that in other words, a bench of lesser quorum cannot express disagreement with or question the correctness of the view taken by a bench of larger quorum. This view finds support from the decisions of this court in the Bhagalpur binding cases, wherein it was said that the court is not helpless to grant relief in a case of violation of the right to life and personal liberty, and it should be prepared to force now tools and devise new remedies for the purpose of vindicating these precious fundamental rights. It was also indicated that the procedure suitable in the parts of the case must be adopted for conducting the inquiry needed as to ascertain the necessary parts for granting the relief, as the available mode of redress for enforcement of the guaranteed fundamental rights. More recently in Union Carbide Corporations versus Union of India stated that we have to develop our own law and if we find that it is necessary to construct a new principle of liability to deal with an unusual situation which has arisen and which is likely to arise in future, there is no reason why we should hesitate to evolve such principle of liability to the same effect are the observations of Ramsay. After hearing learned counsel for the parties, we are of the opinion that there is no reason to hold any contradiction between the medical examination and the age given in her high school certificate, for the reason that the medical examination for determination of age has an inherent variation and diluting both the ways. Therefore, the specific age given in the high school certificate may normally be preferred unless facts and circumstances are compelling. The prosecutrix appears to have been blackmailed, raped against her will, and consent after the accused had taken some obscene photographs of hers. In our considered opinion, the matter was more than 1.5 months old from the date she was raped. Hence, even if no injuries have been found on her body or she has been found to be accustomed to sexual intercourse, would not demolish the allegation of rape. It would also be wholly immaterial whether later on she did not try to run for the reason that she had succumbed to the coercing pressure. She had not consented to sexual intercourse by all four persons, even assuming that Chandu had promised to marry her. These allegations have been levelled by opposite party number 2 against all the applicants, in which he has said that the applicants had overstepped their authorities, and by doing so they got applicant number 1 appointed as the principal of the college by playing fraud. But nowhere opposite party number 2 had disclosed the source wherefrom he got these informations, or how he has got access to the proceedings of the meetings in which the alleged decisions were taken. No details regarding misappropriation of funds has been given in the complaint by opposite party number 2 regarding the cost of cultivation scheme, the construction of boundary wall of the college, and animal husbandry expenditures. Only vague allegations have been levelled in the complaint, and the statement of the complainant under section 200 CRPC. The learned magistrate has not cared to elicit the real facts by cross-examining the complainant on these points. It appears that the learned magistrate has believed all that as gospel truth which the complainant has deposed before him. It also appears that learned magistrate failed to appreciate the fact that in ex parte proceedings, the possibility of giving false statement by a complainant and witnesses is not uncommon. From the opposite report, it also appeared that the charge sheet shall be filed as soon as the evidence came on written stop. It was observed by this court at that point of time that on a perusal of the materials already brought on record, it was difficult to conclude at that stage that the investigation was not proceeding towards correct direction stop. At that stage, we did not find it appropriate to direct the state of Gujarat to include Mr. Ram with Ms. Johri for completing the investigation part. At that stage, it was submitted before this court by the London Senior Counsel appearing for the state of Gujarat that the final report would be submitted within 4 to 6 weeks from 15th of May, 2007. Fifth action taken. Report was dated 2nd of July, 2007. In this report, taking a departure from what was stated in the fourth action taken report, Ms. Johri stated that the Andhra Pradesh police authorities had denied any official involvement of Andhra Pradesh police personnel staff. Examining 194 witnesses, they had been able to arraign another 6 persons as accused stop against the order of the Metropolitan Court, rejecting permission of the court for conducting the narco analysis test of 6 accused persons, an appeal had been filed in the Sessions Court part. The body of Kausar B was cremated on 29th of November, 2005 in Illore village stop. The assistance of Directorate of Forensic Science was sought to establish whether soil samples collected from Illore village contained any remains of a human body. Stop. As per F.S.I. dated 28th of May, 2007, nothing incriminating was found. The investigation was pending with respect to point 1, arrest of 2 police personnel. Point 2, to establish the identity of Andhra Pradesh police personnel who might have unofficially helped ATS officials. Charge sheet was proposed to be filed within prescribed time frame against the accused who was arrested on 16th of July, 2007. This court directed that a copy of the charge sheet must be supplied to the additional Solicitor General of for India within bracket as he then was close bracket. After taking note of the fact that the 6th action taken report dated 14th of July, 2007 was filed in court stop. This report reiterated the stand that no official assistance was rendered by Andhra Pradesh police to ATS Gujarat stop. Charge sheet had been filed in the Court of Chief Metropolitan Magistrate against 13 accused for criminal conspiracy, abduction, wrongful confinement, murder, etc. 13 have been arrested. Stop. One of the 13 accused whose name had been listed. The report expressly states that no link of Tulsiram Prajapati had been established in this case. Stop. The third person who was abducted was not to be said Tulsiram Prajapati. Ms. Johri also stated that the investigation had been carried on in a fair and impartial manner under her direct supervision. It was stated that the writ petitioner did not cooperate with the investigation. Stop. It is also stated that copies of A.T.R. cannot be supplied, as the same would help the accused. On 2nd of August, 2009, the 7th action taken report was filed, which stated that The third person who was picked up was one Kalimuddin, who was suspected to be an informer of police staff. He could be hiding somewhere unharmed. It again detailed the efforts of the state CID, open bracket, crime, close bracket, to make sure that none of the accused goes scot-free. Accused police officers, irrespective of their rank, had been arrested. They were suspended or transferred to avoid their interference with the case. Police personnel themselves had deposed against the accused police officers. No anticipatory bail was granted to any of the accused parties. The accused had challenged subjecting them to narco analysis, and the matter was pending before the court. The report submitted that analyzing the voluminous details of the calls made by the accused, collected from various service providers, would take time. It was also urged that the habeas corpus filed by Rababuddin Sheikh does not survive, as Kasorbi's body was found to be cremated. We have considered the rival submissions of the learned counsel for the appellants and learned AG as the punishment under section